Hi everyone, I'm Syed Fayyaz Ali. I'm an employment lawyer running multinational organizations in my 10 years career. And the topic which I will be speaking is enforceability of non-compete clauses in India. So first, let me give you a background on what non-compete clauses are. A non-compete clause is a provision in an agreement where an employee, while leaving an organization, cannot join a competitor within a fixed span, like a specific time period, which is mentioned under the employment agreement. So nowadays, during these competitive times, this is a very common practice which is going on with the multinational organizations that they ask employees to sign either non-compete agreement separately, or they mention it in the employment agreement, a specific clause which talks about the non-compete clause. So some organizations where I have come across mentions some specific competitor names as well, that you cannot particularly join this organization, these organization within a span of 2 years after leaving the organization, otherwise we'll be taking action against you. So today I will be speaking about the enforceability of these clauses or these agreements. What are their validity under the Indian law, under the perspective of the Indian law? Are these enforceable or not? So to begin with, under the Indian Contract Act 1872, Section 27, which talks about the clauses which are voidable or void clauses. So it says that every agreement which is in restraint of exercising any lawful profession by any person is to that extent is void. So Indian courts also have, constituently, continuously taken this Section 27 of Indian Contract Act while deciding the enforceability of this clause, and have not considered it as a valid clause because it restricts any employee from exercising its lawful profession or trade or business. So it is in violative of the Indian Contract Act, and other than in the Indian Contract Act, Article 19(1)(g) of the Constitution of India provides every citizen right to practice and profess any trade or business. So this is an absolute right under the Constitution of India, and no restriction can be placed under it. Therefore, it is also violative of the fundamental right to practice and profess one's own trade or business. So that is how under two laws, the Constitution and Indian Contract Act, it is governed, and therefore it is not, decided by many courts that it can be enforced. Therefore, whenever an employer goes to the court, it doesn't come in favor of the employer that that this agreement or this clause can be enforced. There are some instances wherein pre-termination it has been enforced. Like for example, if an employee is still working in the organization, and while working in the organization, employees start working for any other organization, any competitor. So in that case, it has been in many judgments by different courts, and one judgment which I would like to quote here is Percept Mark Private Limited versus Zahir Khan and others. So here in this case, this Supreme Court of India has quoted Section 27 of the Contract Act and says that a restrictive covenant extending beyond the terms of contract is void and not enforceable. So the doctrine of restraint of trade, as per the Supreme Court, does not apply during the continuance of employment contract and is applied only when the contract comes to an end. So Supreme Court has quoted another judgment like Gujarat Bottling versus Coca-Cola. In this also, the doctrine is not confined only to contract of employment, but is also applicable to other contracts as well. So in short, the Supreme Court has mentioned that no non-compete clause in an employment agreement is enforceable as long as the employee is performing for the company by the terms of an agreement. So while working with an organization, you cannot join any competitor. Or so in that case, it has been held by in many cases by different high courts and Supreme Court that an employee cannot join any other competitor. So post termination, when an employee has ceased to any relationship with its employer, then employee is free to join any trade or profession or business. There at that time, no restriction can be placed upon the employee as violative of Section 27 of the Contract Act and Article 19(1)(j) of the Constitution. And many judgments are also there by the Supreme Court. There is one judgment which I would quote here. That is Superintendence Company of India Private Limited versus Shri Krishna Murgai. So in this, the question was raised whether a post-service restrictive covenant would fall within the purview of Section 27 of the Contract Act or not. The court held that a contract which had for its object restraint of trade was prima facie void. So here Supreme Court has held it as void. And Delhi High Court also in Foods Limited versus Bharat Coca-Cola Holding has held, that it is well cited that post-termination restraint under Indian law violates Section 27 of the Contract Act. Such contracts are unenforceable, void, and against the public policy, which is prohibited by law and cannot be permitted by court's injunction. So there are many judgments which we can quote here, but for your reference, I have quoted some landmark judgments wherein it has been held as non-enforceable. So concluding to this, so Indian courts have considered pre-termination clause during pre-termination period. The clause has been held as enforceable. But while the courts have been tolerant about the application of non-compete clause, they have after the cessation of employment held that such clause would not fall within the purview of enforceability. So that is all about the enforceability of non-complete clauses with respect to Indian perspective.